Lesson 5. Other grounds. Good comes about from the integral cause, evil from single defects. Aquinas, Summa Theologiae, Prima Secunde. The wisest of the saints and the holiest of the wise, St. Thomas Aquinas, recalls frequently in his treatise on moral theology the old sentence, bonum ex tota integra causa contingit, malum autem ex singularibus defectibus. In English, good comes about from the whole cause, evil from single defects. In other words, a thing is whole when all its essential elements are present. Otherwise, the thing does not exist. For instance, a man can exist without a hand, but not without a soul. That's not a man, that's a corpse. Whenever the intention, the election, or the circumstances are evil, the action is evil. Murder in the name of freedom, for instance, is still murder, and it is evil. Charity for appearance is more vanity than love, and it is evil as well. Exercise is great, but playing a football game in a church is a sacrilege. The circumstances are not good, so the act is evil. This principle of moral theology applies as well to matrimonial consent. All essential defects make consent invalid. Cardinal Pietro Gasparri, in his seminal Tractatus Canonicus de Matrimonio, divides the defects of consent into two groups: things that oppose consent from the part of the intellect, and things that oppose consent from the part of the will. In Lesson 4, we studied exclusion, the main defect of the will. In this lesson, we are going to see condition and fear, the remaining defects of the will, and error and ignorance, the defects of the intellect. 1. Will. Condition. When we studied exclusion, we learned that marriage is invalid if an act of the will opposes marriage as such or an essential element of marriage. The wedding is null as long as the will to exclude is stronger than the will to marry. The same rule applies to any other act of the will that subordinates marriage to a condition. The condition needs to be placed by a positive act of the will. It must be a certain and determinate condition, a conscious act about a known object that was really placed in a deliberate manner at the same time as the matrimonial consent. The object of the condition is irrelevant as long as it is a serious condition and not a mere desire. Conditions bind consent to the presence of a circumstance or quality to the point that the validity of marriage depends on it. In other words, the condition is so serious that unless the requirement is met, there is no marriage. Canon 1102 regulates the effects of conditions on the validity of consent. Conditions about the future are treated differently from conditions about the present or the past. These conditions only make marriage invalid when the requirement is not met. Conditions about the future, on the other hand, always make marriage invalid, regardless of whether the requirement was met or not. Let us begin with the conditions about the future. Paragraph 1. A marriage subject to a condition about the future cannot be contracted validly. Conditions about the future can be resolutive or suspensive. Canon 1102, paragraph 1 speaks about suspensive conditions, not resolutive ones. A resolutive condition is a dissolution clause attached to matrimonial consent. For instance, if you use drugs again, I will divorce you. A resolutive condition does not go against the validity, but against the indissolubility of the marriage. In other words, it is the same exclusion of indissolubility that we studied in Lesson 4. Canon 1102, paragraph 1 is about suspensive conditions, that is, the conditions that intend to subject the validity of the marriage to a future event. Now, until the future event is verified, the validity of the marriage remains in a state of suspense. Moreover, if the condition is perpetual, the suspension would be indefinite. For instance, if the condition is, I am only marrying you if you never try drugs again, even if the requirement is met, it would be impossible to know if the consent was valid until the other party dies. In order to avoid this problem, the law invalidates all marriages celebrated under conditions about the future, regardless of whether they were fulfilled or not. On the other hand, while all conditions about the future are invalidating, conditions about the present and the past are different. Paragraph 2. A marriage entered into subject to a condition about the past or the present is valid or not, insofar as that which is subject to the condition exists or not. As you can see, the code follows natural law for conditions about the past and the present. If the condition is fulfilled at the time of the wedding, the marriage is invalid. Otherwise, it is invalid. For instance, I marry you if the child that you are carrying is mine. Or, I marry you if you have never been arrested by the police. In both cases, the validity of the marriage depends on whether the conditions were met or not. Sometimes, however, what seems like a condition about the future behavior of the other spouse is in fact a condition about the present, by which one spouse conditions the validity of the marriage to a serious promise or commitment at the time of the wedding not to engage in bad behavior anymore. For instance, the condition, I am only marrying you if you never use drugs again, usually means I am only marrying you if you make a serious resolution today not to use drugs anymore. This is actually a condition about the present. Therefore, the validity of the marriage depends on whether the resolution was serious at the time of the wedding, not on whether the promise was fulfilled or not. At our tribunal, we have considered grounds of condition only a handful of times in the last years, and the verdict was always in the negative. Force. Canon 1103 indicates when external forces vitiate matrimonial consent. A marriage is invalid if entered into because of force or grave fear from without, even if unintentionally inflicted, so that a person is compelled to choose marriage in order to be free from it. According to the canon, therefore, we have two defects of consent caused by external influences against the will: force and grave fear. Force, also known as violence, is the physical coercion to get people to act against their will, like, for instance, to obtain someone's consent at gunpoint. This external, physical, and perceivable violence is evidently extremely uncommon. We have never even set a ground of force as per Canon 1103 at our tribunal. Grave fear. Grave fear, on the other hand, is a relatively common ground. It takes place when fear is the reason why the will issues consent. In this sense, there is an act of consent which would be sufficient in itself to create a marriage, but the law makes it null to protect the dignity of marriage. Only grave fear can render consent invalid. The pressures must be so threatening that they bend the will of the subject. This means that the gravity of the fear is relative to the capacity of the individual to resist threats. Indeed, the same pressures that would completely freeze a weak youngling may seem insignificant to a mature and strong adult. Because the threats compel to choose marriage, there must be some aversion to the wedding. Otherwise, the will is not bent or broken by the threats, which are just a reinforcement of an existing will to marry. The grave fear of Canon 1103 comes from without, not from inside of the mind. Grave fear is not an autosuggestion. Even if the subject feels threatened, there is no grave fear if no specific individual has generated that state of mind. For instance, if the parties marry due to so-called societal pressure, there is no grave fear as per Canon 1103 because the fear is not instilled by anyone in particular. On the other hand, the threats may be unintentionally inflicted. In other words, maybe there is no intention to generate fear as such, or maybe the threats are not aimed at obtaining matrimonial consent. In any case, the threats generate a subjective state of fear in the subject, who feels trapped to the point that marriage seems the only way to escape the danger. This is different from fair warnings and wise advice, like the insistence of a parent who reminds the parties that they are living in sin and that they should marry to give a stable home to their children. This is true as well in cases of arranged marriages. In some cultures, parents arrange the marriage of their children. It would be extremely unfair to say that arranged marriages are invalid. If the parties trust their parents to choose the right partner for them, accepting the cultural norm, there is no grave fear. Consent is invalid when the parents impose their will against the will of their children. There is a special type of grave fear called reverential fear, which is the fear of losing the respect, the trust, or even the relationship itself with a revered person, like a parent, a boss, or a priest, whose desires are perceived as orders. Given the intimate nature of the relationship, the threats may not be issued directly or explicitly, but they derive from the revered person's behavior. Even though this is not a ground of natural law, grave fear applies to everyone, Catholic or not, baptized or not. There are two grounds that can be easily mistaken with grave fear: lack of internal freedom and total simulation. Indeed, the three grounds have in common an aversion to the wedding and are usually connected to external influences of one kind or another. While it may be difficult to distinguish among them in practical cases, the difference is very clear in theory. In cases of incapacity, the will is unable to even issue the consent. In cases of total simulation, the will is able to consent, but rejects marriage with a positive act. In cases of grave fear, the will issues the consent, but this consent is invalid because of the fear. Case 1. Jake and Jessica dated a few times. They were young and they had intercourse. Jessica got pregnant. Both Jake and Jessica's parents agreed that they should marry. Jessica refused, alleging that she didn't love Jake and she wasn't ready to marry him. Her parents threatened her with kicking her out of the home. She complied, married Jake, and divorced him as soon as he turned 18. Case 2. When the communists took over Vietnam, V's family lost everything and had to face misery and hunger. V was young and beautiful, and she was in love with Nam, her boyfriend. Nam's family was even poorer than V's. They both were Catholic. V's mother broke her heart when she instructed her to marry a communist leader, as it was the only way to save the family from poverty. V cried and cried. She hated the marriage. She did not want to do it. She was in love with Nam, but she knew she had to obey, and obey she did. 2. Intellect. The main criterion for defects of the will is prevalence. We ask ourselves what prevailed, the will to marry or the will to exclude. The main criterion for defects of the intellect is whether the error is essential or not. An error about the essence makes consent invalid. An error about an accident does not. Only essential error makes consent invalid. The defects of consent that come from the intellect are ignorance and error. While they are certainly two different things, for our purposes, ignorance and error are synonyms. Ignorance and error have the same effect on the validity of matrimonial consent. When it comes to matrimonial consent, there are two types of error: error of law and error of fact. Error of fact is the error about the other spouse. Error of law is the error about the matrimonial contract. In both cases, if the error is about the essence, consent is invalid. Otherwise, if the error is about an accidental aspect, it does not make marriage null. This is not difficult to understand. We cannot want what we do not know. For instance, Julius Caesar could not want an iPhone because he did not know about its very existence. On the other hand, we do want things while we ignore their accidents. For instance, when you signed up for this course, you gave your consent to study this lesson, even though you did not know its content. You knew the essence and you gave your consent to it, but you did not know the exact content, the font that could be used, and many other accidents, and you gave your consent to them as well. Canon 1097 regulates error of fact. Paragraph 1 describes the error about the person itself, and paragraph 2 the error about a quality of the person. Paragraph 1. Error concerning the person renders a marriage invalid. Paragraph 2. Error concerning a quality of the person does not render a marriage invalid, even if it is the cause for the contract, unless this quality is directly and principally intended. Error about the person. An error about the person makes marriage invalid because it is an essential error. Naturally, someone who is mistaken about the identity of the other party to the marriage does not issue a valid consent. This is what happened to Jacob, who intended to marry Rachel, but was fooled by Laban, who gave him her sister Leah instead, as we read in Genesis 29. This error is about the physical identity of the person, not about the personality. For instance, when a woman complains about her husband saying, "He's not the man I used to know anymore, he's a different man now," this must be understood as a poetic expression. He is the same man. His behavior has changed, but he's not a different person. As you can imagine, error about the person is extremely rare. It could happen, for instance, in weddings celebrated by power of attorney, where the groom and the bride cannot see each other while exchanging their consents. In any case, there is no record in our tribunal of a ground of error about the person in the last decades. Error about a quality principally and directly intended. Error about the person makes consent invalid because it is an essential error. Error about a quality does not, because it is an accidental error. This is what we read in the second paragraph of Canon 1097. Error concerning a quality of the person does not render a marriage invalid. Indeed, everyone is mistaken about certain qualities of their respective spouses on the day of the wedding. Only God knows everything, and the spouses learn many things about each other during the marriage. Obviously, these errors do not make marriage invalid. But the canon goes even further. An error about a quality does not make a marriage invalid, even if it is the cause for the contract. In other words, even if the quality was the reason for the marriage, the consent is not invalid. This type of error is called error dans causam, or error that gives the cause for the marriage. This would be the case, for instance, of a man who marries a woman because she's rich, while in fact she's poor. His consent is naturally sufficient to marry. He is choosing to establish a permanent partnership open to procreation through sexual intercourse with this poor woman whom he believes to be rich. He is mistaken about a quality, about an accident, not about the essence or identity of the woman. Therefore, his error dans causam does not make the marriage invalid. On the other hand, when the error is about a quality directly and principally intended, consent is invalid. This is the only case in which an error about a quality of the other spouse makes marriage invalid. Let us see how it works. First of all, the quality is a stable quality. A quality is not an action performed in the past, but a feature of the person. Moreover, this quality is intended directly and principally. A quality is directly intended when a positive act of the will seeks that quality in a deliberate and determinate way at the time of the wedding. This is not the same as discovering some bad quality after the wedding and regretting the choice that was made. On the contrary, the errant considers this quality particularly relevant already before the wedding. The quality is a particular feature that is sought in the other spouse. It cannot be mistaken with general virtues that everyone looks for in a marriage, like for instance, being loyal and kind. But this error does not invalidate consent. The quality is something peculiar and distinctive, like being a virgin or an engineer. Furthermore, the quality is principle intended. That is, the will of the quality is prevalent. The desire for the quality is stronger than the will to marry. In other words, the quality is more important than the person, qualitas pre persona in the typical expression of canonical tradition. Ultimately, this means that the quality becomes a condition of validity for the consent. Since the quality is not present, the consent is invalid. You have probably perceived that this ground has a lot in common with exclusion and condition. Indeed, strictly speaking, this ground is not a ground of error, but a ground of condition. What makes the marriage invalid is not the error, but the implicit condition that was present at the time of the wedding and aimed at the quality. The error about the quality is the occasion for the condition to make consent null. The condition can be about any quality. Indeed, if consent is conditioned to a quality, whatever the quality may be, and the quality is not present, there is no consent. In theory, matrimonial consent can be conditioned to any quality at all. In practice, however, it would be very odd that someone subordinates the validity of the marriage to a spurious or irrelevant quality, like being blonde or owning a cat named Willie. Moreover, this error is very difficult to find because typically someone who is so invested in a given quality verifies thoroughly that the prospective spouse has the quality before getting married. If there were some suspicions and no further investigation was conducted, that is a sign that the quality was not principally intended. An important element of proof in these cases is the reaction of the errant when the truth is revealed. If the quality is so important, we can expect a strong reaction, like breaking the relationship or being mad for a long time. Case 3. Roma culture gives much importance to the virginity of the bride, to the point that there is a huge celebration when the elder women of the family declare that the bride is a virgin. José and Lola from Spain had been married for 2 months when he learned that she was not a virgin on the day of the wedding. He immediately returned her to her parents among threats and insults. Ignorance of the essence of marriage. Now let us consider the error of law. In Lesson 1, we defined the essence of matrimony as a permanent partnership between a man and a woman ordered to procreation through sexual congress. This definition comes from Canon 1096. Paragraph 1. For matrimonial consent to exist, the contracting parties must be at least not ignorant that marriage is a permanent partnership between a man and a woman ordered to the procreation of offspring by means of some sexual cooperation. Paragraph 2. This ignorance is not presumed after puberty. Since we only want what we know, whoever does not know the essence of marriage cannot marry. Ignorance of any of these essential elements makes consent null. However, as the canon says, it is rare that anyone who has gone through puberty does not know about these essential elements. This is an extremely rare ground. It could take place, for instance, in the case of someone who gets married without any awareness whatsoever of sexuality. If spouses do not know that sexual organs need to get in contact, they are unaware of an essential element of the contract of marriage, and the consent is not valid. It would also be the cases of a savage, like Tarzan, coming out of the jungle. He may be aware of sexual intercourse, but has no clue about a permanent partnership between a man and a woman. Case 4. Binh was raised in a small farming village in Vietnam. Everyone was Catholic in the little town. She was married at 18. At the time of her wedding, she did not know anything about sexual intercourse. She thought that children were conceived by the mere fact of living together and that babies came out of the anus. She had a prenuptial class at the local parish, but they did not speak about sex at all. On the night of the wedding, she was terrified when Nam tried to touch her. He showed her pornographic videos to initiate her. Determining error. Non-essential errors about the contract of marriage do not make consent invalid. This is what we read in Canon 1099. Error concerning the unity or indissolubility or sacramental dignity of marriage does not vitiate matrimonial consent, provided that it does not determine the will. Canon 1096 speaks of permanence, not indissolubility. As we saw in Lesson 1, permanence belongs to the essence of marriage, while indissolubility is an essential property of marriage. Knowledge of permanence is required for marriage, but knowledge of indissolubility is not. The same happens with the other essential property and with the sacramental dignity of marriage. No one needs to know about them in order to get married. This is why Canon 1099 establishes that error concerning the unity or indissolubility or sacramental dignity of marriage does not vitiate matrimonial consent. The essential properties and the sacramentality of marriage, while extremely important, are not essential knowledge required to consent to marriage. Actually, the name essential properties is not random. The properties follow the essence and they pertain to every marriage, but they do not belong to the minimum knowledge required to marry. In other words, ignorance of the properties is irrelevant. Exclusion of the properties is detriment. In fact, if the error about the properties and sacramentality made consent null, most marriages would be invalid. Think about it. Muslims and many other cultures accept polygamy. Saint Joseph wanted to repudiate our Virgin Mother. The apostles thought that marriage without divorce was not worth the effort. Protestants do not believe that marriage is a sacrament. Orthodox, Protestants, Jews, Muslims, Buddhists, many Catholics, and virtually everyone in the world today and throughout history accepts some form of divorce. If these errors make marriage invalid, the very institution of marriage becomes useless. Nor in vain The Catholic Church always presumes the validity of these marriages. However, Canon 1099 includes a controversial clause, provided that it does not determine the will. These words appeared with the new code in 1983 without any basis on the tradition. Until today, it is unclear what they mean exactly, and none of the many proposed theories is accepted by the majority of scholars. There certainly have been abuses in the application of this enigmatic clause under the new and controversial ground of determining error. We do not use this ground at the Metropolitan Tribunal. Error due to fraud. The grounds of error that we have seen so far are based on natural law. In other words, the consent given under these errors is null because it is naturally insufficient to create a marriage. There is another ground of error that is not based on natural law. The legislator introduced this ground as a matter of justice to protect victims of deception. It is indeed extremely unfair to be bound for life by a marriage that was only celebrated because of fraud. However, since this is a positive ecclesiastical law, it only applies to Catholics. According to Canon 1098, a person contracts invalidly who enters into a marriage deceived by malice perpetrated to obtain consent concerning some quality of the other partner, which by its very nature can gravely disturb the partnership of conjugal life. The English words deceived by malice translate the Latin dolus, an intentionally perpetrated fraud. In other words, the error is created by a deliberate choice to deceive with the intention of obtaining matrimonial consent. This is not an involuntary mistake. The deception is the reason for the error, and the error is the reason for the marriage. Without fraud, there would be no error. Without error, there would be no consent. It does not matter who deceived the errant. The author of the fraud can be the other party to the marriage or someone else, like a relative or a friend. The error is about a quality that is stable and important. As we saw with Canon 1097, paragraph 2, isolated actions in the past, vague and general traits of character, etc., are not qualities. Moreover, the quality must be important in the sense that it has a grave negative effect on the marriage. Case 5. Jason left the seminary after realizing that priesthood was not his calling. He went back to his home parish and after a while started dating Tina, a parishioner he met at the young adults group. One evening, one thing led to another, and they had sex. It was Jason's first time. A few weeks later, she told him that she was pregnant. Jason decided to do the right thing and married her. They had Cynthia, a gorgeous baby girl. When Cynthia was 3, Tina left Jason for the real father of the baby, a pilot that Tina had been dating before and after the wedding to Jason. Jason showed me the picture of Cynthia. She had blonde, long curls and green eyes. With clouded eyes, Jason told me how Cynthia would tell him once and again, "Daddy, don't leave me! Daddy, don't leave me!" Like this one, all the practical cases of the course are true stories.